Hello and welcome to this video. My name is Marco and I am a member of the Blockchain Presence project. As one part of my work, I am examining the legal perspective under Swiss law on a possible initial coin offering, or short ICO, for a so-called equity token. In the next few minutes, I want to give you an overview over the most important steps that need to be done in order to launch an ICO. At this point, please note that given the broad variety of possible forms of ICOs, and depending on the individual situation of a business, those steps can change significantly and additional steps might be needed. Because of that reason, the following video should only be understood as one possible approach, and specific requirements should be thoroughly checked in every individual case. For the purpose of this video, I tried to condense the, in my opinion, most important legal aspects into 5 key points, which are defining the basic conditions, checking applicable law, creating the tokens, writing a prospectus, and executing the ICO. These 5 steps can sometimes be interdependent and are therefore not strictly chronological. Subsequently, I will talk about these 5 steps in more detail, but before doing so, let us reconsider the initial reason for the ICO. The main goal of nearly every ICO is to raise funds. These funds are then typically used for further development and propulsion of the project. This is done through a sale of coins, also called tokens. A token, as I will use it, means a digitalized representation of a right, usually on a blockchain basis. However, the tokens that are sold can have very different characteristics, and depending on those particularities, the consequences for the technical and legal requirements change, sometimes even dramatically. Thus, it is crucial to define the basics in the first step. At this early stage, the fundamental questions need to be clarified. Of special importance are questions like, how much money do we want to raise, and how much money are we realistically expecting to raise? Are there any other, better, more promising sources of funding, like for instance debt financing or funding through angel investors? Once you are positive that you want to offer tokens, follow-up questions might revolve around issues such as, whom do we want to address? Is it a certain type of investor? Is it the public? Is there a minimum number of tokens we need to sell such that we do not actually lose money? How many tokens are sold and at what price, etc. Further, a question of vital importance arises, namely, what rights does an acquirer of our token get? Simply put, we need to define what exactly we are offering. As previously mentioned, different properties of the tokens can lead to a different legal treatment. Unfortunately, there is no broad consensus yet about the classification of tokens. This having said, many regulators have published some sort of guidance. For instance, the Swiss Financial Market Supervisory Authority, short FINMA, distinguishes between payment token, utility token, asset token, and hybrid token. In this framework, payment tokens, also called cryptocurrencies, are, as you might have guessed, intended to be used as means of payment. Utility tokens provide access to a digital service, usually in the context of a blockchain-based infrastructure. Asset tokens represent assets such as shares, bonds, or derivatives, and hybrid tokens refer to those tokens who show characteristics of more than one type of the before-mentioned tokens. For the rest of this video, I will focus on issuing equity tokens, and in our case, these equity tokens fulfill the exact same purpose as traditional shares. Thus, they qualify as asset tokens under the framework of the FINMA. Now, in the second step, we need to thoroughly check what legal consequences emerge from such a classification. It cannot be stressed enough that this step should be done very carefully, as the success of an ICO is heavily dependent on a serious legal evaluation. Generally, in every country the token is offered, regulation must be met. Just because an ICO is approved in one country does not mean that it is automatically allowed in another country. Further, from being completely forbidden to hardly being regulated at all, almost everything is to be found regarding regulation of an ICO. Returning to the example of the equity token offering, this means that given we fulfill all the Swiss regulation concerning the ICO, this does still not automatically empower us to offer equity tokens in, let's say, the European Union, for instance. So let's have a look at the legal situation in Switzerland to get an impression of how a legal system can regulate an ICO. Again, this example only holds for tokenized shares. To begin with, we must acknowledge that an ICO is not explicitly regulated under Swiss law. However, this does not mean that it is not regulated at all. In fact, for the emission of shares, Swiss law tends to be principle-oriented, which means that, generally speaking, there is only little difference whether a share is issued in a traditional or in a tokenized way. The first thing that should be checked is if a capital raise is needed. For instance, this could be the case if the issuing company intends to buy and resell its own shares to new investors and only has the bare minimum of equity capital. The second question should be whether the bylaws of the company must be changed. For instance, this could be because of the necessity for a capital raise or because terms for transferability of shares have to be updated. It should also be checked how the share register can be kept, what criteria the tokens have to fulfill, and again, if the bylaws must be changed accordingly. The third question should revolve around an authorization inquiry towards the FINMA. Depending on the characteristics of the tokens, the ICO might be subjected to the supervision of the FINMA. And finally, any person issuing traditional or tokenized shares must prepare a prospectus unless you can make use of an exception. This prospectus contains all relevant information for an investor. Once we have addressed all legal questions, in a third step the tokens should be created. Keep in mind that the tokens might have to fulfill legal requirements as mentioned before. As opposed to the emission of traditional shares, equity tokens usually cannot be created through the ICO itself, but have to be created prior to being sold. The creation of tokens itself is a rather technical process, which is why I won't go into detail. Having laid a good foundation in steps 1 to 3, we need to write sort of a fact sheet in the fourth step. Many companies publish what they call a white paper. In general, a white paper contains detailed description about the technologies used and oftentimes also pieces of code and information about a conducted security audit. It is extremely helpful as a marketing and information tool. However, a white paper is usually neither regulated nor standardized and therefore does not always include the same information. Also, the interpretation of what actually is a white paper can sometimes differ. As already outlined before, many countries demand a prospectus. A prospectus is a clearly regulated document that contains detailed information about the company, the industry, the offer, and especially also about the respective risks. While there might be some overlap between the white paper and the prospectus, the latter is more focused on legal and business issues. Once the prospectus is written, it usually has to be approved by and deposited at an authority, and only then can it legally be named prospectus. Again, for our example, the applicable regulations for Switzerland can be found in the Financial Services Act and in the Financial Services Ordinance. Apart from the specific content the prospectus must contain, those laws specify provisions regarding review, deposit, and period of validity. At the very latest, the prospectus must be publicly available with the start of a potential public offer. Moreover, advertisement should always refer to the prospectus. The fifth and final step is then of course the public offer itself. As for traditional shares, Investors can buy shares at a previously set price for a previously defined period. In the blockchain world, shares are usually sold in exchange for established cryptocurrencies. Some modifications to the offer are imaginable. For example, there could be a pre-ICO where some shares are offered at a lower price for investors who are willing to buy first. Also, an auction-based pricing model or incentives for investors, for instance, 1 free share per 10 paid shares, are conceivable. However, such modifications should be legally checked beforehand. Now let me conclude. Blockchain is a relatively young, yet very promising technology with a broad field of possible applications. While the possibilities seem to be nearly endless, there are as well some other aspects that we should keep in mind. Seen from a legal perspective, this means that in this thriving and dynamic market, legislators cannot always keep up with the fast pace of digital evolution. Especially when it comes to blockchain, there are still many things unclear, leaving us to some extent with legal uncertainty, which also has to do with the scarcity of case law. It is therefore advisable to always keep an eye on the latest legal developments. We are now at the end of this video. I hope that I could give you a first overview such that you are now ready and motivated to dive deep into the fascinating world of blockchain. If you have any input, please feel free to contact or follow us, and thanks for watching.